Hi, welcome to my video on causation in the law of negligence. So we've already looked at two of the essential elements that you need to make a claim in negligence. So there has to have been a duty of care owed, and then that must have been breached by the defendant falling below an expected standard, depending on who they are, of course. The final element is one that students often struggle with, so it's the mark of a really high student if they're able to tackle this well, and that's causation. So the claimant's got to show that the defendant's breach actually led to their harm or loss, that it wasn't coincidental, that they are to blame. And the law requires both factual and legal causation. There is a little exception to be aware of res ipsa loquitur. So if you can't prove causation, but the facts clearly speak for themselves, then we might be able to forego this element. So in very, very rare situations, like in the case of Scott and St Catherine Docks, in that case a bag of sugar fell. It wasn't clear how or why it fell, but it clearly fell because it wasn't secured very well, so it must have been the defendant's fault. But generally speaking, you're going to have to prove that it factually and legally caused the harm. There are four elements to causation, so if you can remember A, B, C, D and apply those or evaluate those in the exam, then you should be able to do well here. The first is a key part of factual causation, the but-for test. We simply ask, like we do in criminal law, but for the defendant's breach, would the claimant have actually suffered the harm or loss? If you struggle with the concept of but-for, an alternative word would be without. So without the defendant's breach, would the harm have still happened? We saw this in the case of Barnett versus Chelsea and Kensington Hospital Management Committee, where the poison in the tea had been so deep in the claimant's system that even if the doctor had done a good job, they wouldn't have been able to save him anyway. But for the doctor's bad treatment, would the claimant have died from poison? And sadly, the answer was yes. He would have died anyway. So therefore it's not the doctor's fault. So even though the doctor clearly broke the duty of care he owed to his patient, it didn't lead to the harm caused, and therefore we can't sue them for it. The answer has to be no. Without the breach, would they have suffered the harm or loss? No, it only happened because of something bad the defendant did. And that's why we continue looking at the rest of causation. The next thing the claimant has to show is a clear, unbroken chain of causation. And again, this works in a similar way to criminal law. There must be a clear link between the defendant's breach and the harm the claimant is suing for. There has to be no novus actus interveniens. And if you're not comfortable with Latin, the translation is intervening acts. There has to be nothing that breaks this chain, because if there is something that breaks the chain, the claimant needs to sue them instead. There are three potential novus actus interveniens or intervening acts to look out for. There could be the unreasonable act of the claimant themselves. There could be an unforeseeable act of someone else, a third party, perhaps a doctor giving the treatment. Or there had to be a terrible unforeseeable act of nature. Now, in the case of Wieland versus Cyril Lord Carpets, the claimant had been injured in an accident at work and she had to wear a cone around her neck. She walked down the stairs in her house, she couldn't see where she placed her foot properly, and she fell down the stairs, injuring herself further. She tried to sue her employer, not just for the original neck injury, but also the subsequent injury from the fall. Now, if we ask the but-for test, but for the original accident, would she have fell? The answer would be no, because presumably, without the accident, she wouldn't be wearing the cone, and then she would have been able to see. So she only fell because of the defendant's original breach. The defendants tried to argue that her going down the stairs with a cone was a novus actus interveniens, a silly action of her own that broke the chain. However, the court said that walking downstairs Although tricky with a cone on is not unreasonable, how else are you going to get around your house? Therefore, it didn't break the chain, and we could attribute it all back to the defendants. Hopefully, so straightforward so far. Now remember, even if the chain is broken, the defendant will be still liable for any original injury. In the case of Baker versus Willoughby, for example, the claimant was involved in a car crash. He had a leg injury, an ankle injury. So he had to leave his job, whatever he was doing at the time was quite physical, and he took a job working as a petrol station attendant. While he was working there, a robber held up the petrol station and shot him in the leg. He had to have his leg amputated as a result. So we sued the original driver for the ankle injury. And the defendant tried to argue that he shouldn't be responsible for any of it anymore because there is no longer a leg to sue over. Now, but for the original car accident, would the claimant have lost his leg? And the answer is, well, no, because it only happened because he was only in that job because of the original car crash. Was there a novus actus interveniens? Was there an unforeseeable intervening act? And the court said yes. The act of a third party, the robber, broke the chain between the car accident and the loss of leg. So he couldn't sue for losing his leg. However, they were still liable for the hurt ankle, even though the ankle was no more. That's because you're still liable for the part that you did, even if someone else comes along and breaks the chain. The next element is part of legal causation. And this isn't looking at whether the defendant is or isn't liable, it's whether they should be. Should they be held responsible for the claimant's harm? So the question is of remoteness of damage. Was the damage foreseeable? And if damage is foreseeable, it makes sense that you should therefore avoid it. Or was it too remote to claim for? Now, remote is just a fancy word for unforeseeable, and that's the question you're asking. Was the injury foreseeable or not? If it wasn't foreseeable, harsh as it sounds, we can't really expect the defendant to try and avoid it. If it was foreseeable, they should have avoided it. And we saw this in the case of Wagon Mound number 1. So the oil spill led to the claimant's wharf burning down. Was it foreseeable? No, because generally oil on water doesn't set fire. And the court said it wasn't foreseeable that you would get fire damage, just environmental damage from an oil spill. So even though the claimant did factually suffer a loss, legally the defendant wasn't held responsible because it wasn't foreseeable. Now, remember, when it comes to foreseeability, we don't have to get our crystal ball out. You only have to foresee the general type of injury that'll happen, not necessarily how bad it'll get, or exactly how that damage will come about. In the case of Bradford versus Robinson Rental, it's foreseeable that if you make an employee travel in a van with no heaters, where they have to put the windows down to stop them steaming up, on a day with terrible weather, it's foreseeable they'll get a cold-related illness. Now, the claimant suffered hypothermia, which is a very, very extreme form of cold-related illness in this country. It's very rare. However, all we had to foresee was the type of injury, not how bad it would get. A cold injury was foreseeable, a cold injury was what Mr. Bradford had, therefore he could sue. Now in Hughes, that was the case that involved the uncovered manhole where the boys accidentally knocked an oil lamp into the hole and there was an explosion. It was foreseeable that if the boys played around in that area without supervision, they might get burnt. There was oil lamps everywhere. We didn't have to foresee exactly how, so we didn't have to know it was going to be an explosion, but it was foreseeable the type of injury they could get burnt. So therefore they were able to sue. Nice bit of alliteration there. How is Hughes? The final element of causation, you don't need to look at in every scenario question. I would only discuss this if it's directly relevant to the scenario. In other words, if there are any hints of the thin skull rule. Sometimes you see it called the eggshell skull rule, means the same thing. So I would only discuss this if it's relevant. A, B and C are the three key elements of causation. The thin skull rule says that if the original injury was foreseeable, so this links back to part C, remember it has to be foreseeable to claim for. If it's too remote, in other words, remote means far away, if it's too far away from thought, you can't. But if the original injury was foreseeable, the defendant will also be liable for any consequences if it happens to be worse because of who the claimant is. So in the case of Smith versus Leach brain, was the original injury foreseeable? Well, if you don't provide adequate cover for someone working with molten metal, it's foreseeable they could get burned. The original injury was foreseeable. And remember, we don't necessarily have to know how bad the burn would get, and we don't necessarily have to guess exactly how he would end up burned or where, but is it foreseeable he would get burned from a splash of molten metal? Yes. Now, it just so happened that in him, that burn triggered pre-existing cancer cells. Should the defendant be liable for that cancer that wouldn't have triggered in everybody else? And the court said yes, because you've got to take your claimant as you find them. You have to protect them. If they happen to suffer worse because of who they are, that's tough luck. Now, remember, we don't have to foresee the cancer. Cancer would probably be very remote. You would just have to see the original kind of cause, which was the burn, and that clearly was foreseeable. So for causation, we need A, B, and C to be satisfied. And then look into accounts for D if that person happens to suffer extra because of who they are or a decision they've made. Causation is actually quite simple. Learn and understand your cases and remember it as A, B, C, D. Thanks for watching.